Okay. So good evening, everyone. I think we will get started. So again, I am Angie Rogers. I am the Deputy Chief Administrative Officer for Economic Development for Prince George's County. And thank you for tuning in to this second conversation regarding rent stabilization in Prince George's County. As many of you probably know, the Prince George's County Council earlier this year passed two bills, CB7 and CB 51, to set and then clarify a policy for rent stabilization in Prince George's County. The agreement between the administration and the council also at the time was to set a work group that would spend roughly the next year digging into this issue more in depth in order to devise a permanent rent stabilization policy for the county. That work group has been convened. They will begin their work officially in the weeks to come. But before they officially began their work, we wanted to do these fact-finding discussions to allow specifically our work group members to hear from experts in the field who have experience with rent stabilization from a number of different sides. A couple of weeks ago, we heard a presentation from representatives from the Urban Institute and also ULI Minnesota on sort of local and national best practices related to rent stabilization. Tonight, we are going to hear from another dynamic panel focused on tenant impact. Tonight, we have with us Jessica Kinkosa and Kayla Williams-Campbell from Community Legal Services of Prince George's County. We also have with us Erica Puentes Martinez and Jorge Benitez from Casa de Maryland. So we will hear presentations from both of those groups. In between those presentations, we will take a couple of minutes to take clarifying questions from members of the work group. And then the second half of our time tonight will be a more general discussion, and work group members will have the ability to ask more general questions of our panel. Thank you to the members of the public who have logged in this evening. This discussion, as I said, is really for fact-finding and the ability for our work group to start to dig into this topic and start to frame the discussion that they will have over the next year. But the members of the public can certainly interact with us tonight through the chat, through the Q&A. We do plan to, over the course of the work group's work, have some additional sessions that will be more sort of town hall style that will allow the public to weigh in directly with us. So that's our lineup for this evening. Before we get started, I want to hand it over to Connie Serrano Portillo, who is going to welcome you on behalf of our esteemed District 7 Councilmember Crystal Oriada. Connie?
Thank you, Angie. Good evening, everyone. Unfortunately, the council member could not join us tonight, but she did want to send her regards and just say thank you to CASA and Community Legal Services for tonight's presentations. We're very excited to hear from all of you, as we know that renters and families have been highly impacted by rent increases all across the county. So we're excited for this session and all the great things that will come out of the work group. And we're hoping to also see you tomorrow at the Landlord and Development Impact session. So thank you so much. I'll kick it back to Angie.
Thank you so much, Connie. So we are going to get started with our representatives from Community Legal Services, and I'll invite you all to pull your presentation up and get started.
Good afternoon. I'm Jessica Kinkosa. I'm the Executive Director of Community Legal Services, and I have the task of moving the slideshow along for Kayla, who graciously created this slideshow, and I'm here to answer any questions. Give me 1 second, and Kayla, if you want to introduce yourself.
Good evening, everyone. My name is Kayla Williams Campbell. I'm a managing attorney with Community Legal Services, and I oversee our eviction prevention programs. We currently have 2 eviction prevention programs, one in Prince George's County that operates out of the Hyattsville District Courthouse, and we also have an eviction prevention program at the Anne Arundel County that provides representation in the Glen Burnie and Annapolis District Courts. Both of our programs focus on providing free representation to low-income and underserved tenants who are facing eviction. And so tonight, we're going to talk a little bit about rent stabilization, how it impacts tenants, and why we believe it's important, but also why tenants believe it's important. I'm going to just go through a little bit about what is rent stabilization, as well as some of the numbers in terms of eviction filings and why these policies are important, particularly in Prince George's County. So first, I would like to talk about what is rent stabilization. I know that rent stabilization and rent control are often used interchangeably. However, rent stabilization, these policies allow for certain rent increases for a fixed amount. So currently, Prince George's County has passed rent stabilization bills that allow for a 3% increase, whereas rent control would provide that a landlord cannot raise rent past a certain amount. So it's intended to protect tenants from price gouging and make housing more affordable. So I'm sure that all of you have witnessed what's been happening throughout the pandemic. It's like as soon as those pandemic moratoriums lifted, a lot of tenants experienced extreme rent increases. And so I'm next going to talk about the 2 bills that have passed by the county, or that have been passed by the county. And then we'll go into why it's important for tenants. So CB 7/2023, this is the first Rent Stabilization Act that was passed by the county. This prohibits landlords from increasing a tenant's rent by more than 3%. This legislation is temporary, so it will expire after a year. And there's certain exceptions that do apply. And I think these exceptions are important to talk about because they could possibly preclude a lot of tenants from being able to take advantage of the Rent Stabilization Acts. So again, according to this legislation, landlords cannot increase rent by more than 3% within a given year. However, there's exceptions. So if the tenant is living in an affordable housing that is backed by federal, state, or local subsidies, this Stabilization Act would not apply to them. Additionally, if the tenant is living in a dwelling unit and they're currently receiving rental assistance, it also would not apply to them. If the tenant is living in a unit that is providing affordable housing to low income or moderate income households, it would not apply to them. And lastly, if the landlord has obtained a use and occupancy permit within the last 5 years, this act would not apply to them. And so I think the most important, in terms of us representing tenants, I think the most important exception would be that this act does not apply to certain tenants who are receiving rental assistance, because a lot of our clients, a lot of tenants that we represent are low income and they are currently facing rental assistance. They are currently seeking or have recently obtained rental assistance. And there is an enforcement authority. So if a landlord does not abide by these rent stabilization bills, I'm sorry, Jessica, can you go back? Thank you. If the landlords are not abiding by the rent stabilization bills, they can face fines. So they could face a fine of $500 for the first violation, and they could also face a $1,000 fine for any subsequent violations. Okay, next slide, please. Thank you. Okay, so the second Rent Stabilization Act that was passed in Prince George's County is CB 51, 2023. This particular legislation prohibits landlords from retaliating against tenants retaliating against tenants who seek enforcement of CB 7, 2023. So for example, if a tenant believes that their rent has been illegally raised more than 3%, they can report their landlord to the county, or they can consult an attorney to get legal advice. If the landlord then threatens to, say, terminate their lease or reduce some of their services, like turn off their water, turn off their electricity, fail to provide lack of maintenance, all of these things are considered retaliatory under this act. So what happens is if a tenant is being retaliated against, this particular act provides them a recourse. And I believe that the enforcement authority is still DPI, the Department of Permitting, Inspections, and Enforcement. And it's for our purposes, of course, if a tenant were to face a court summons or an eviction hearing, we could also provide representation in court and raise certain defenses in regards to those illegal rent increases. So again, CB 51, 2023 provides tenants with a remedy for if they are being retaliated against for in terms of the Rent Stabilization Act. So again, if the landlord is harassing the tenants, if they're threatening to file an eviction, if the tenant doesn't pay illegal fees, or if they're decreasing services, all of those things could be retaliation and could give the tenant a recourse. It's important to note, though, that the same exceptions or exemptions from CB 7, 2023, they also apply to CB 51. So if the tenant has received rental assistance, or if they're living in certain government-backed properties, this may not apply to them. So now that we've talked about the bills that the county has passed, I would like to talk about why rent stabilization is important for tenants. And next slide. Thank you, Jessica. So why is it needed? So for one, Prince George's County has always or notoriously had pretty high rent. It seems to have gotten higher throughout the pandemic. But in addition to the rent already being high, towards the end of the pandemic, we started to see a lot of landlords increasing tenants' rent significantly. We've seen rents be increased as much as $400. In some cases, I think we've even seen a tenant's rent be increased by $600. Oftentimes with little notice. So a tenant's lease may be nearing expiration, and in order to renew that lease, they may then have to pay an astronomical rent increase of $400, $500, $600. That's on the higher end, of course, but we did start to see that a lot. Additionally, a lot of our tenants were already burdened by the financial hardships that the pandemic brought about. So a lot of tenants were facing job loss, they were facing illness, they were being caregivers, and for those reasons, they were already falling behind trying to catch up. A lot of them were seeking rental assistance. And now that rental assistance is somewhat dwindling, it may not be guaranteed in the long run. It's even more important for these bills to be in place. And additionally, inflation has affected everyone in everything, including groceries and gas. And because of the rising costs, many tenants are being priced out of not only renting, but also homeownership. And we're concerned that if there are not rent stabilization policies and certain caps in which landlords cannot increase rent, we're concerned that it could increase homelessness and it could cause a mass exodus out of the county. And as I mentioned, rental assistance, although it is still available, we anticipate that it will decrease at some point in the near future. We're hoping that it is put in the budget, but that is a concern that we're also looking at. Majority of the tenants that we represent, we're starting to see less defenses. A lot of the tenants just need assistance paying their rent. So if these laws are not in place, then the concern is, although the tenant may receive rental assistance, although they may catch up, then they can't continue to pay the increased cost of the increased rent. Next slide, please. It's important to note that there's no state law that talks about rent increases or stabilization. So the Maryland Real Property Code says nothing about how much a landlord in Maryland can or cannot raise the rent. So they leave it up to the individual municipalities and counties. So that's why it's important for the counties to look at this legislation and analyze how it can impact the tenants that are living in their areas. And again, with no rent stabilization policies, landlords are allowed to increase rent in any amount. That's what we were seeing prior to the rent stabilization acts being passed. And additionally, a lot of times when rent is increased, you may not always be, or those increases may not always be reflected in the actual property. So what we also see is a lot of times tenants' rent will be increased, $200, $300, but there will be no upgrades to the home. There's lack of maintenance, continued maintenance issues, safety issues. I know there's been some press about some properties in Prince George's County who have had a lot of maintenance issues. Well, we're concerned that even if the landlords increase the rent, we may not see that rent or that increase actually impacting the tenants positively. They may not actually be receiving the maintenance that they've been concerned about all this time. And lastly, we're concerned that lack of rent stabilization will result in the continued increase in eviction filings. On the next few slides, I'll include some statistics that are, I'll talk about eviction filings in Prince George's County and why it's so important, particularly in this county, that we have some type of rent stabilization legislation in place. So Prince George's County has, I believe, the second highest eviction filings in the state of Maryland. We're preceded by Baltimore County, I believe. And I'm focusing on failure to pay rent cases because those are the cases that mainly involve rent. And so why are filings so high in the county? For one, if you look at the cost to live in Prince George's County, that's one factor you have to consider. Additionally, it's extremely cheap to file a failure to pay rent case. So it's only $15 to file it. And so that's essentially giving landlords no incentive to not file. But additionally, we believe a lot of landlords use failure to pay rent cases as a debt collection measure. So unfortunately, we'll see some tenants who are being summoned every single month because they are having trouble catching up. And although they're seeking rental assistance, that's a process. And so I think that's a reason why some of the filings are so high. And additionally, the demographic and socioeconomic factors. Statistically, Black people and Black women in particular are more likely to be evicted. And if you look at Prince George's County, I know we're very diverse, but demographically, there are a lot of people of color, a lot of Black women, and a lot of Black people in general. So that's another reason why we believe that the filings are so high. And on the next slide, I just prepared these filing statistics came from the Maryland court's website. So as you can see, in fiscal year 20, so that was right before the pandemic, so from July 2019 through July 2020, you can see there were 111,000 filings just for failure to pay rent. As you can see, the other cases, there's pretty small amounts of them. Tenant holding over is when a landlord's alleging that a tenant's lease is expired, and as a result, they want them to move. Breach of lease, wrongful detainer, those are pretty straightforward. But as you can see, the failure to pay rent case filings are extremely high. That was before the pandemic and right when we got into the pandemic. Of course, in fiscal year 21, so that's from July 2020 through June 2021, filing rates went down because at that time we had a lot of moratoriums and protections in place. So this prevented, this allowed certain tenants to raise defenses that may not have otherwise been available. So if they were facing financial hardships that were caused by the pandemic, they could raise that in court. And so we saw a reduction in fiscal year 21. However, we are starting to see a significant increase as of fiscal year 22. And of course, we're still continuing to see that increase. So as you can see in fiscal year 21, there were 52,000 failure to pay rent cases filed. And then in fiscal year 22, there were 70,000 cases filed. And also, as you can see, the tenant holding over cases have gradually increased every year. So that's another concern, is that when, during the pandemic lasted over a year, of course, over 2 years, essentially. And so landlords were just saying, you know what, we're not going to file the failure to pay rent cases because there's protections available, but we're just going to file tenant holding over cases because the tenant's lease has expired. And as a result, we want them out. But one concern with tenant holding over cases is that the landlords can tell the tenant your lease is expiring and will allow you to renew, but if you want to stay here, you'd have to pay the increased price. So that's where rent stabilization can be helpful. Even if the tenant's lease does expire, the landlord could only increase that rent by a certain set amount, which would allow that tenant to stay housed and to prevent them from hopefully being displaced. Next slide, please. So we understand that rent stabilization can't fix everything. It's not the answer to everything. So I also wanted to briefly discuss some laws that have been passed on the state level that are also hopefully going to impact tenants positively. So specifically in regards to rent increases, so there is now, as of October 1st, 2023, there will be the requirement that landlords provide tenants with a written 90-day notice that their lease will be increased. That their rent will be increased. That 90-day notice provision is for year-to-year leases. If a tenant is a month-to-month tenant, the landlord would still be required to provide 60 days written notice for any type of rent increase. Now, localities such as Prince George's County and other municipalities, they are still able to enact their own policies, but I think it's important to note that according to this legislation, counties that do enact rent stabilization laws, they'll be required to report on the number of new housing, multi-housing construction permits in their jurisdiction. And another piece of legislation that was passed on the state level that could also be helpful for tenants would be proof of rental licensure and actions to repossess. This is essentially will help we believe it will help the landlord tenant process be a little bit more level. So currently, landlords are only required to show that they have a rental license and a failure to pay rent case. So if they come to court and they file one of these cases, they're required to show their license for failure to pay rent. They wouldn't have to do the same for tenant holding over a breach of lease case. However, in October, they will be required to provide a license for all of these cases. And so that is another piece of legislation that will hopefully impact tenants positively. And next slide, please. And there's also in October, there will also be a rental assistance voucher program established by DHCD. And this will provide $15 million of rental assistance to people who are waiting for rental housing assistance or for the federal housing voucher program. So this is another policy that will help tenants who are potentially facing either displacement or eviction. And next slide, please. So there are some collateral effects of rent stabilization. So one of the things that we have been seeing, which I think is important to note, are landlords. So although the county legislation is clear that landlords cannot charge more than 3% for certain tenants. What we're starting to see is some landlords are now charging new fees to try to circumvent that legislation. So these fees can be disguised as things like maintenance fees, pet fees, parking fees, utility fees. You'll often hear the tenants say, I've never been charged this before. They've never seen these things. And so we have been receiving more calls about these new fees. So essentially, although they're not increasing the tenant's rent, they are essentially still doing the same thing. It's just disguised as a different fee. And so although we may be able to argue against these additional fees in court in like a fair to pay rent proceeding, the concern also is the tenants could be bound contractually if they sign the lease agreeing to these fees. So that's something to think about. Another concern potentially is we may start seeing more landlords file tenant holding over cases. So if a tenant's lease expires, we could see landlords then try to increase their rent. And then lastly, just enforcement. The enforcement authority is DPI. Once a landlord is reported to DPI, the concern is then what happens next? Will the landlord actually be fined? And that would be the end of our presentation. And I think we have time for questions.
Sure. Thank you so much, Kayla and Jessica. We'll take a couple of minutes to take clarifying questions from the work group before we move on to CASA's presentation. And I'll get us started with a first question or two. You brought up the concern about tenants who are receiving rental assistance and potentially not being protected by this policy. We had a lot of conversation in the first session about the potential effect of exempting any kind of subsidized housing. And we think of rental assistance, as really sort of one of the best tools that we have for protecting affordability. So I'm wondering if you can talk a little bit more about what's the potential harm? What kind of scenarios could you see play out for a tenant who is receiving rental assistance but not protected by this law?
Sure. I think we're starting to see it now. So if a tenant is receiving rental assistance, I think my primary concern would be that the rental assistance will cover what they currently owe. But then moving forward, they may not be able to. So moving forward, if they receive rental assistance, they may not be protected by the rent stabilization bill, which would then mean the landlord could increase their rent by whichever amount they choose once their lease expires. So I think that would be the biggest concern that we have. And we see that already. We've seen tenants who have received a substantial amount of rental assistance, but they still have had trouble catching up on the rent, even without the rent increases. So I think that would be my primary concern.
I think the concern is if it's already slightly unaffordable for the tenant and they had to receive rental assistance moving forward, how will you maintain that sustainability for the tenant to be able to afford it if it's not stabilized?
Yeah. I see that Ms. Cook from Chair DeNova's office has joined us, so I elevated you to panelist so you can ask your question directly.
Well, thank you. I appreciate that. We learned recently in my office that that the 3% increase goes with the apartment, not with the person. Is that correct?
I don't think I can confirm that. I didn't see that on the. I don't know if there's a clarification on the actual bill. Jessica, can you speak to that?
I'm not sure, but I'm going to double check because I know that there's an info sheet. I thought it was with the actual, the person that was currently renting that unit. But give me a couple minutes. I'm going to look it up for you.
Yeah, please check. That's my understanding as well, Jessica, but I would, appreciate you checking.
Give me 1 second.
Okay. In the meantime, can I move to Aspasia?
Yes, thank you. And I
Sorry,
wanna-
Director Zapolia.
No, Aspasia sounds great. I do want to clarify to your question, it is with the existing tenant. It is not with the apartment in this law. But I want to clarify some information that was provided on the rental assistance, because when we say rental assistance, it means very different things. People who receive ERAP were never excluded. What we always said was that permanent rental assistance, so either a project-based voucher or a tenant-based voucher, and that they are still excluded. And there is a science and a reason for that. It is because HUD establishes the maximum rent, and HUD also says what is the tenant's portion. The rest comes from the government. And so there are federal regulations that clarify how this works. And so if a tenant's income doesn't increase, their rent doesn't increase. It increases only when their income increases, and HUD determines what that is. And the maximum rent that is allowed is determined by HUD to the landlord, and they can collect it, but it is covered by the federal government, and it does help with operations. So I want to clarify that because it is a very important point as we make local laws, to have them consistent with all other federal programs that are very valuable. And I also want to clarify some information, Kayla. In your presentation, you said that CB 51 still has all the exclusions. It doesn't. The only exclusion that exists now in CB 51 is for permanent, for those who have either a project-based voucher or a tenant-based voucher, and that is for the reasons I just explained. So for clarity purposes, I will put on the chat for everybody both the notification we have in our website that we work with DPI and our Office of Law, and the FAQs that are very clear who is excluded and who is not. But ERAP was never meant to be excluded. It was not excluded on CB7, and it wasn't excluded on CB51 either.
Or Ms. Cook, can I go back to you to see if you have another question?
Yes, thank you very much. In one of the earlier slides, it noted that if there was a UNO for a particular, I guess, apartment complex, that I'm assuming that, if there were a new owner in the last 5 years, that they were exempt from the 3% rent stabilization. Do I have that correct?
Yes, that's according to the legislation.
Okay, that's the first time I had heard that. So that's interesting, because we had a case where, an apartment complex was recently bought, and I would say in the last 3 years, we were not aware of that at all. So we were going under the assumption that, these people had the right to, that they had the right to expect to only pay a 3% increase, but that was incorrect, evidently.
Well, I want to clarify too that this is for new construction. So it's
new
not-
construction. Okay, because it didn't say
Yes.
that. Thank you very much for saying that. Thanks. Yeah, that was my question.
Okay. Can I go to Ms. Lundy?
Yes, thank you so much. Let me come on camera. I may be a little dark coming on.
That's all
Sorry,
right.
Kate. Okay, hold on. Okay. Oops, sorry. I said I had the NAACP.
That's all right.
Thank you so much, Ms. Campbell, for your presentation. It was very thorough. In one of your slides, you talked about the notification of rent increases to be annually or month to month. So in my own case, what my landlord did was to give us options. So instead of taking the 3%, like you said, they disguise these fees. So they have extended my term of my lease. So what are the parameters for those persons who are outside of the year lease, outside of the month to month, but they may be in 15-month lease, they may be in a 20-month lease. So I want us to consider that. And do you have any feedback on that?
Well, I think if your lease is for a set term, it would be considered a year-to-year lease. Usually month-to-month leases are if there is no set term. So if your lease has expired and you're just going month to month. So in your case, so that legislation doesn't take effect until October of 2023, but your lease probably still talks about how much notice the landlord would be required to give you to increase rent, but it may only be something like 30, possibly 60 days. And so the new legislation will possibly extend or increase the amount of notice that's required to be given by your landlord.
All right, thank you so much.
Thank you. Miss Powell. You're on mute.
Sorry about that. Good evening, everyone. Thank you, ladies, so much for your presentation. I just had a quick question, and it's from one of your earlier slides. And I'm sorry, I'm from Southern Management Companies, large presence in Prince George's County. So we're very invested in this issue. But I've heard a lot about these increases that are well beyond reasonable, right? And so I'm wondering if there's been some sort of survey of apartment communities in the county to show whether this is really an example of a few bad actors, or if this is an issue that is wide sweeping across the county. Do we know at this point?
I personally don't know about a large scale survey. I can only speak about the conversations I've had with our clients, our tenants who are experiencing the rent increases.
Okay. Thank you.
So let me thank you all for clarifying questions on this piece. I'm going to ask Kayla and Jessica to hang around for the end to take more questions. But at this time, I'd like to move on to the presentation from Casa de Maryland and have Erica and Jorge present to us, and we'll do the same thing after their presentation. We'll take some clarifying questions, and then we can open it up for general discussion. So if I can hand it over to Erica and Jorge and let them get started.
Good evening, all. My name is Erika Puentes Martinez. I'm a research and policy analyst for CASA.
My name is Jorge Benitez Perez. I am the lead organizer for Prince George's County with CASA. CASA is the largest immigrant and working class rights organization in the Mid-Atlantic region. Some may be familiar with our legal services. Our team has been representing folks in eviction court, helping tenants access rent support and other services. But today we are going to focus on policy.
We are here representing the interests of around 150,000 Black and Brown immigrant and working class families, many who are braving the housing affordability crisis. With a nationwide hike in rent paired with the not so coincidental skyrocketing homelessness rates and eviction rates, Black and Brown working class residents need strong tenant protections now. And of course, one of those tenant protections is a strong permanent rent stabilization bill for PGC. Opponents to rent stabilization, developers, landlords, frequently insist that the housing affordability crisis can be remedied if only the government minimizes interference in the market. Government regulation through rent stabilization, they claim, would only discourage housing development, promoting issues with supply and demand. Firstly, we must address that myth. Rent stabilization does not have a negative impact on new construction. This fact is supported by numerous longitudinal studies conducted in jurisdictions included but not limited to Jersey, the Bay Area, Berkeley, Los Angeles, and nearby Washington, D.C. This is most likely as a result of rent regulation policies typically instituting carve-outs for new construction, just like our temporary CB7 includes. As you can see, these findings have been published in numerous journals. However, I asked the council to carefully consider the following. If, as opponents claim, the housing affordability crisis is a result of a market flaw, low supply, high demand, why would we turn to the market-based solutions to remedy this issue? In this case, their market solutions are to combat and or reduce any sort of rent regulations under the presumption that the market will sort itself out, as if it were some sort of race neutral space. Yet history proves that the real estate market is far from race neutral. This market has been fueled by racial discrimination. It's helped craft racial segregation. And Prince George's County is no stranger to the racist practices of the real estate market. Many Black and Brown residents are still struggling to regain stability after the Great Recession of 2008 hit this county particularly hard. Financial institutions preyed on Black and Brown communities with high-risk subprime loans. This predatory and racist lending practice shaped the housing collapse and left so many of our residents without homes. It didn't take long for private equity firms and Wall Street-backed landlords to leverage our community suffering for their own gain, swoop in, buy hundreds of thousands of foreclosed single-family houses and apartment complexes, which largely shapes our current-day crisis. With investment firms targeting Black neighborhoods, buying a large portion of the housing stock nationwide to be turned into rental housing units, it significantly decreases any avenues for our communities to reach home ownership. As MacArthur Genius Fellow and housing scholar Keonde Imada Taylor simply puts, can't buy a house must be the rent, no matter how high. We are essentially dealing with a captive Black and Brown renters market who are at the mercy of these corporate landlords.
These corporate landlords, knowing they dominate the market, aggressively increase the rent. And here are just a few examples of what CASA has encountered in Prince George's County. The apartments listed on the slide vary widely in number of units. All of the apartments have raised rents over 10%. 10% is considered a constructive eviction, meaning it is an alternative way outside of the court process to evict residents. Some of these buildings have raised it through fees rather than rent. Fees include transaction fees, landscaping fees, administrative fees, playground fees, trash fees, month-to-month fees, amenity fees, parking fees, water fees, and utility fees when they were previously included in the rent. Now, after CB7, these buildings are not including these items in rent and are tacking them on top of rent to bypass the bill. Most of these properties have out-of-state corporate owners. It is important to recognize that these aren't just studies or numbers. There are real people suffering the very real consequences. I will now pass it to 3 people who are residents from this list: Chia Jefferson, Magdalena Torres, and Eddie Mayorga. They are Prince George's County residents who have felt the effects of this injustice.
Good evening, everyone. My name is Kia Jefferson, and I have lived in Laurel at Patuxent Place for the past 18 years. I received this time last year an increase of $800 more a month. That is a 56% increase. That is absurd. No one has ever heard of an increase that high. I received my increase at 9 o'clock at night via email, and I only had 23 days to find a new place to live. I immediately went down to the rental office the very next morning to speak to them. And there was no nothing. That was normal to them. They thought that an $800 increase with a 23-day notice was perfectly fine. I want to add that my unit has been occupied for 18 years. That means no renovations, nothing. They were charging me $100 less than the completely new renovated units. That means no new paint, no nothing. And their solution was, you can move into a temporary unit and then move back into a renovated unit. So now on top of an $800 increase, I'm asked to pay to move twice. There's just no reasoning behind that. So what does an $800 increase mean for the average person? Well, I figured if they're going to charge me $800 more a month, I can go buy a house. So I ran out and got pre-approved, and the house, the cost for housing, that was too much. So that whammed me. So I was stuck there. for yet another year. Now, technically, my lease should start again in September. It's after July. I still have not received a new rent. I still have not received a new lease. In this past year, they have raised the water, and they are also threatening trash fees. But $800, that is not a, let me, work on my budget situation. That is a whole nother person. That's a whole nother person in my household, to come up with that type of money. So I just wanted to share my story. So when you hear of 200, 300, 400, no, there's people out here, 800, $1,000 in my complex. Thank you.
Buenas tardes, mi nombre es Eddie Mayorga.
Good afternoon. My name
Vivo en los apartamentos de Westgate en Laurel, Maryland, y soy miembro de casa.
I'm sorry, can I interrupt just a second? I think there's someone translating for Mr. Mayorga, and you need to get closer to the microphone as well. Thank you. Go ahead.
La razón por la que estoy aquí es por la renta y los aumentos. Mi renta fue aumentada a más de $100 al mes. Soy de la clase trabajadora y un aumento así no es fácil para mí y mi familia.
My rent was increased over $100 each month, and that is not an easy increase for me who is working class.
Tengo hijos en la high school que me ven trabajar mucho y no pueden pasar tiempo con mi familia.
My high school age children see me working all the time and wonder why I can't spend time with family.
Yo he vivido en el condado de Prince George alrededor de 20 años y no me gustaría irme de este condado.
I have lived in Prince George's County for 20 years, and I do not want to move from this county.
Ya que toda mi familia y amigos están ubicados en este lugar y al salir de este condado implica dejar todo.
My family, my friendships, everything that I've built in this county over the last 20 years are here, and having to move means I give up everything that I've built.
Ya que todo esto me ha costado por años construirlo, les pido por favor continuar protegiendo a la comunidad más vulnerable en este condado de Prince George.
I have worked hard to build my family here in Prince George's County, so I ask that you guys continue protecting our vulnerable families here in the county.
Y ayudarnos a pasar la estabilización de renta.
And let's pass a rent stabilization law. Thank you.
Buenas tardes, mi nombre es Magdalena y vivo en mi apartamento en Greenville por 5 años. Tengo una familia maravillosa con 3 hijos menores de edad, uno de 18, de 14 y mi hija de 11.
Good evening. My name is Magdalena, and I live in Greenbelt. I have lived in my apartment for 5 years. I have a wonderful family with 3 children, one who is 18, the other is 14, and my daughter is 11.
Debido al aumento en la renta, se nos ha complicado pagar las cosas como comida, medicamentos para mi esposo que acaba de tener una operación.
Due to the increases in rent, it has made it difficult for us to buy medication.
I'm sorry, we're having the same issue again where we can't hear the translation.
We have had issues because of the rent increases paying for the bare necessities as food and even medication. for my husband who recently had a surgery.
Thank you.
Yo me quedo en el hogar cuidando a mi hijo de 14 años que tiene necesidades especiales y necesita de mi cuidado.
I stay home with my son who is 14 years old because he has special needs and needs of my care.
Debido a los altos costos de la renta y en un accidente también de un árbol, siempre ellos han tratado de aumentarnos, nos llegó de $100 más.
Our last increase happened when we had an incident where a tree fell on our building. And even after the tree fell on our building, what we received was a $100 rent increase.
Mi hija Allison ha visto cómo sufrimos esta pesadilla de los altos costos de renta. Ella quiso compartir unas palabras.
My daughter Allison has seen how much we have suffered this nightmare of these extreme rent increases, and she wanted to share a few words.
Hello, my name is Allison Torres. My family has lived here in Greenbelt for almost 5 years, and I reached the Hello, my name is Allison Torres. My family has lived here in Greenbelt for almost 5 years, and I reached the 6th grade this year. I do not want to move from here, and I know that my parents and Casa are doing everything possible for us to stay here. And when I found out that we were being kicked out of a house because the money was too much, I was scared because I felt that we were going to live on the streets. I have my friends here and I have been here all my life, and I want to focus on school, not worry about where I live.
Unfortunately, these aren't unique cases. The effects of these rent increases are not a result of just a few bad actors, but are rather part of an insidious nationwide trend. According to a congressional subcommittee report and expert panel from June 2022, while single-family rental units provide great returns for investors, they have high eviction rates, poor maintenance, high hidden fees, and aggressive rent increases. Likewise, investment firms neglect maintenance and hike rent and additional fees in apartment buildings to the detriment of tenants. Tenants just can't keep up. From 2000 to 2020, the share of renters who are rent burdened increased from 41% to 50%. This is affecting mostly Black and Latina women. Rents have been going up more than inflation for years. As you can see in this chart, graphing pre-pandemic years in a local area, rent in red climbs higher than CPI in blue. Following a similar trend nationally in recent years, rent in red continues to climb higher than CPI in blue. And locally, since the pandemic hit, rents have skyrocketed across the region.
Rents in Prince George's County have gone up 14% over the past 2 years. Rent increases over 10% are considered constructive evictions, which means a lot of people have been forced out of their homes as a result of extreme rent increases. It is important to understand that there is a huge power imbalance between renters and landlords. CASA members cannot simply move to a cheaper apartment. They often sublease rooms to afford the apartment they are currently in. They often have no credit, so they cannot move to another property. They often don't have enough money to pay for the first month's rent and security deposit, not to mention the uprooting that moving causes to their jobs, their kids' schools, etc. Despite rent increases rising more than CPI over the last decade, this was not always the case. This chart shows how prior to the 2000s, CPI and rent increases went up almost the same amount. So why has that changed more recently? Could it be concentration of financing in an unregulated rental market? Could it be bigger profit margins for owners and landlords? Regardless, this shows the need for regulation in the rental market. Here is a graph of how rent-burdened families were in Prince George's County in 1990. Here is a graph of how rent-burdened families were in Prince George's County in 2020. As you can see, the percentage went up 14% over 30 years. Rent burden means that families are paying more than 30% of their income towards rent. Severely rent burden went up by 11% from 14% to 25% over that same time period. That means 25% of families are paying over half of their income towards rent. Clearly, we need a new approach outside of building more housing to protect renters. Before Prince George's County put a 3% cap on landlords, they were able to increase rents whatever they wanted to, even if their costs did not go up. Rent stabilization will require more investment in housing because only landlords that can show they are putting money into a property will be able to ask for the reasonable rate of return exemption. Permanent rent stabilization does not affect new development of housing. We absolutely need more housing, and we need to incentivize building affordable housing with tax credits, housing trust fund money, etc. What we don't need is to lose affordable housing like it is happening across the Washington metropolitan region. We have seen rents go up by hundreds of dollars in numerous multi-unit apartment complexes, and we have seen fees from playground fees to administrative fees to parking fees to landscaping fees to trash fees tack on even more charges onto tenants. The situation is impossible for renters to continue to afford, and we need rent stabilization to combat inequality and the racial wealth gap. Thank you.
Thank you. So we will take just a couple of minutes to do some clarifying questions and then sort of open it up for general discussion. And I will get started with my first question. You guys talked a lot about this issue about fees, which was something that our panelists from Community Legal Services brought up as well. And I'm wondering if you can just say a little bit more about sort of what does that look like, like once a tenant might get to an eviction proceeding, if they've also got all of these fees sort of piled up that haven't been paid.
Yeah, so, if they are in that eviction proceeding, what this means now is that their debt and what they owe is significantly higher than what it would have been if it was just, the regular rent charges. We've seen folks get water fees now added onto their leases, and sometimes these water fees are in the triple digits. So imagine having that month to month as a charge on your rent. That can be a burden to many families.
And I'll invite other work group members to turn on their cameras and or unmute themselves in order to ask any clarifying questions. But I'll ask another one, which is someone posted in the question and answer about sort of this issue of gouging. And I'm wondering if for you all, if there's a distinction sort of between the two things, between this issue of gouging versus a, landlord sort of charging moderate increases, each year to cover their expenses, and sort of where do you draw that line if you do, and how do you see it, sort of being stepped over? Wait, Jorge, can you move closer? Yep. Okay.
So yeah, there is a distinction, right, in both, but what we want and what we're pushing for is for rent stabilization. As we know, that is the purpose of this work group, right? It's a rent stabilization work group. And that is what we are going to push for. And that is what our communities, our CASA members have advocated for.
Other members of the work group want to ask any clarifying question about the presentation from CASA? If not, I want to invite our other panelists from Community Legal Services to turn their cameras back on. And maybe we can get into some more general questions. And the question I want to start with goes back to a point that I think you both made in your presentations, which is about sort of what the landscape looks like, you know, particularly for lower income renters in the county, sort of what they're facing and where a rent stabilization policy fits in, you know, with like how to, if I can sort of say what I think, you know, like our collective policy goals are, you know, which is to, you know, promote housing stability and to prevent evictions. Like how does this fit into that? What are tenants facing, particularly lower income tenants, and how does this policy fit in?
So once a tenant is evicted, they're more likely to continue to be evicted. So I think rent stabilization will make it hopefully easier to avoid the first eviction. Not only does the tenant face the eviction, once they are evicted, some of the management companies, if there's a lease term that's still outstanding, they may get sued. They may get sued for damages. Some of the tenants get sued for eviction fees. So then they have a money judgment that follows them that can cause wage garnishments and additionally other issues in the future in their credit. So rent stabilization hopefully can limit that, that from occurring. Also, the lack of affordable housing in the county is pretty substantial. Most of the clients that we're looking at live in a few of the apartments that are on the lower end of rents. And if without rent stabilization, those are going to start becoming unaffordable for them. There's not going to be anywhere for them to really go. So I think rent stabilization can be effective in maintaining the units the folks housed, but also maintain folks paying their rent timely and avoid the additional costs that it costs a landlord to keep evicting, you know, the costs of evicting the tenants and that sort of thing. So I do think that it may be a win-win if there's some agreement amongst both parties.
You brought up something, and you know, I remember hearing this statistic. It's been a long time ago now, and I don't even know if I'm quoting it right, but I remember hearing this statistic that says something like, you know, once somebody is evicted, like they are likely to be evicted again, like within the next like 2 years or 18 months or something like that. And so that the idea that it can be this kind of domino effect, I think is an important point to make.
I don't know how long the time is between the two, and I don't know if the pandemic affected that. But that is a statistic. Once you've been evicted, you're more likely to continue to be evicted.
I want to continue to invite other panelists to come on camera and ask questions. I see Paul has got his hand raised. Paul, can I go to you?
So you call me Carlos. I just put my
Carlos, sorry.
Yeah, but yes, it's okay. A question about the I saw a lot of stats up here. Well, maybe from you guys, but from the CASA group. Does anyone have any stats they're going to break down between the bigger apartment complexes that tenants rent from the smaller like townhomes and condos? Is there any kind of stats that have that distinction? Because look at the CASA stats. I know y'all didn't bring those up, but those seem to be all apartment complexes.
Jorge or Erica, do you guys want to speak to the stats that you pulled?
To answer, we don't have the stats on like compared to, you know, townhouses and stuff, but we have seen bigger increases in rent when it comes to corporate landlords.
Okay, got you. Thank you. And as far as the attorneys on Kayla and Jessica, the clients that you're dealing with, are they mostly from the apartment complexes and corporate owned as well?
I would say, I think the majority, yes. Yes, just because there's more of them, there's a lot more apartment units.
And the data that we used is from the Maryland Judiciary Data Dashboard. It's the Administrative Office of the Courts, and there should be a more timely data dashboard, which should have started a few months ago, but unfortunately, due to the way that failure to pay rent cases are filed, they're filed manually in paper. The court is still getting up to speed. There should be more additional, live data coming up. It's called the eviction dashboard, and that's starting to be populated. That's why our data is a little outdated. It's just what's readily available for the judiciary.
Okay, thanks. That helps give me an idea like the trends and patterns are like, because housing is so complex and nuanced, and trying to see like where are the problem areas or the places where there's probably more problems than others. Just it'll help us identify it as we go through the work group. So thank you.
Yeah, and Carla, someone brought this up in one of the question and answer, the comments and question and answer, just about this sort of difference between small landlords and larger ones. And I know when the landlord conversation happens tomorrow in our prep, that was one of the topics that we talked about covering as well, sort of, the different types of landlords that are out there. And, should they be dealt with differently in a policy?
Thank you.
Anyone else? I'm going to start sort of scrolling through some of the questions that have been put in from our attendees, but other members of the work group should feel free to chime in. There's a question here about if there are exceptions in the existing policy for senior housing. I'll let you guys chime in on that. I don't think, unless it is some sort of committed affordable senior housing, that there isn't anything, at least in the existing policy, for like senior housing as a category. And you guys can back me up on that if you know.
You're correct. So unless there are 202 properties or with project-based or tenant-based vouchers, they are not exempt. And this is part of our FAQs.
There was a question or a stat on the community legal services slides about the large number of failure to pay filings. I think it was like 111,000 or something like that pre-pandemic. And can you just clarify, is that, so that's not 111,000 households, that's landlords like filing multiple times on the same household? Like what makes up that number?
It could be individual households where there's one case filed at one time, or it could be one household where multiple cases are filed. So it's just the amount that's filed every year. That does not mean those cases go to trial. Some of those cases are dismissed prior to the hearing because the tenant pays. So some landlords, rent is due on the 1st, it's late on the 5th, they'll file on the 6th. And at some point before the hearing, I think they're at, right now in Prince George's County, maybe a month or two before the hearings are set, the tenant has in fact paid. So some of those cases don't go to trial and the case is dismissed prior to the hearing. Some of those cases do go to trial, but the tenant has the ability to pay and stay. So that's why, while the filings are higher, the amount of actual evictions isn't not as high as the number of cases that are actually filed.
And this is maybe a side but related question. To what extent do those tenants like come to court or come to the process with any kind of representation, or are they, for the most part, representing themselves?
So the great thing about our program is we provide same-day representation. So if tenants show up and they are income eligible for our program, we will represent them at their failure to pay rent hearing. They can call ahead to receive our services as long as they're income based. We have at least 2 or 3 attorneys available at each docket to represent them. We have some Spanish speaking attorneys also that are there. We do an intake, we review their documents. It's really helpful when the tenant shows up with their checks and anything else that they can prove that they've paid the rent. We review the filing to see if they have any defenses. Some of the defenses are whether or not the landlord is currently licensed. So when the tenant does show up, there are services available to them. Some tenants unfortunately don't receive notice of the hearing until a few days before. Failure to pay rent service is different. In most civil cases, the way that you're properly served is they serve you or somebody at your abode or by certified mail. Failure to pay rent cases, services placement on the door to the apartment. Just because it's for a repossession of property, it's not for the actual money. Especially in Prince George's County, judges don't give any actual money judgments. It's for repossession of property. So you have to pay the amount of money that you owe in order to be able to stay or redeem the property. So service can sometimes make it difficult for tenants to show up, but if they do show up, there are services available. CASA also provides representation, as does Maryland Legal Aid. There is the Access to Counsel program, which is funded by the Maryland legislature. We receive funding through the Maryland Legal Services Corporation. Tenants have access to counsel. It's different from right to counsel. Not every tenant will receive representation, but the goal is to hopefully help as many tenants as we can when they arrive at their hearing.
So I want to clarify also, and I had asked this question when the CASA folks were up, but want to revisit with you as well. And it's regarding the extra fees that get charged and sort of what happens if a tenant ends up in court. I want to clarify, can a landlord take a tenant to court like based on not paying those fees, or is it only the non-payment of rent and then the fees come into play?
So there's actually a appellate court decision, which is a 90-page decision that discusses that topic specifically. It's in the appellate court. It's been appealed to the Supreme Court of Maryland, so we'll see what happens with that. Our position is, which is what the court sided with, is that while a failure to pay rent is for rent specifically. So you look at the contractual terms, rent is the sum due every month. So the amount that's due over the 12 months. And that is specifically the only thing that can be filed in a failure to pay rent. Remember, a failure to pay rent is solely for repossession of that property. So to evict the tenant. There is still that contractual obligation for the fees under the lease that can be revisited in a money judgment, in a civil case. And it's actually for Prince George's County purposes. If you have a civil case, it will be in the Upper Marlboro Courthouse. Any landlord tenant matters are in the Hyattsville Courthouse. It's just how the cases are divided. So our position would be that the amount that can be charged on a failure to pay rent, so what's due and owing for the purposes of an eviction, is what the actual rent is. It does not include those additional charges. And that's what our attorneys argue in the hearing. Some of the things that are included in a failure to pay rent is the late fee, which is only 5%. It's only allowed to be 5%, and any of the filing fees for the failure to pay rent case. So if the tenant loses their case and a judgment is entered because they do owe the rent, in order to stop the eviction, if a warrant is filed, the warrant is what allows the landlord to come, the sheriff to come out and actually execute the eviction. the amount that's due will be on the warrant of restitution, and that includes the $15 filing fee plus $5 per tenant. And I clarified that in one of the chats. And then there's a $40 warrant fee. So that's all going to be included when you need to redeem that failure to pay rent case. So it's two separate cases that are actually tend to happen with landlord tenant cases. Hopefully that makes sense. The 90-page appellate decision makes it clearer, but still not 100% clear.
Got it.
Yeah, I just also, I agree with what Jessica said, right? Fees are technically not rent, so folks shouldn't be evicted for them, but unfortunately, that's not what's happening in reality. And that's why, in this rent stabilization legislation, there needs to be something that addresses fees as well.
So you're saying, so there are people who are being evicted based on not paying fees?
So I think that comes up, especially if the tenant does not come into court to represent themselves, or if it can occur if they're not represented. The landlord could come in and explain with their ledger where the fees are, and it gets muddied when you're looking at a ledger and fees are being applied, rent is being applied incorrectly. So I think representation is very important in that specific type of case. And I think that's what George was trying to say. If he accidentally, he muted himself.
I got it. Okay. And so then I guess, particularly, for the folks that CASA works with and represents, if you have folks who, have language barriers or just like other work or other things going on, that there are lots of reasons why someone might not show up like on their own behalf.
And I want to clarify that we're not saying that they can't collect those additional fees. That's for a different hearing. That's for a hearing before a judge on the contractual obligation from the lease, as opposed to
You're saying that
to pay rent. For the rent purposes of eviction, those fees should not be included.
Okay. Yes, I got it. Hopefully everybody else got it too. Let me go to Shola. Shola, you're breaking up a little bit.
So I think just address the box between which is usually in leases, there is a clause that says that any funds that are paid will be applied to past due balances, irrespective of whether they are fees or actual rent. So,
I don't know. Hold on just a second, Shola. Yeah, is anybody catching that? I want to make sure that it's not my connection that's breaking up. Shola, I don't know if you can put your question either in the chat or in Q&A, because I don't think we can hear you. In the meantime, let me go back to Miss Cook. You have your hand raised?
I've got my hand raised. Sorry, I was trying to turn my camera on. We're always told to have our camera on. So,
oh, yes, I turned it, you missed my, at the beginning, I think my thing to the panelists to, when not speaking, to have their camera off. I can turn you back on, though.
Oh, it doesn't matter.
Okay.
That's why my camera was on for so long. So two things. Number one, if anybody on the Zoom meeting lives in District 1, which is like Laurel, Beltsville, parts of Adelphi, North College Park, we would be happy to help you, talk to you about the process, and make referrals. And then the second thing I wanted to ask is, did we get clarification about, the rent being, or the 3% raise in rent? Does that go with the individual or does it go with the apartment?
So it goes with that individual renewing that lease in that apartment.
Okay, thank you for clarifying that.
It's on the FAQs. It's specifically, I can send you the link. I just went through.
Mhm.
So this is what it says, is the 3% rent cap apply to only current tenants? Yes, applies to tenants who are currently residing in their units who are renewing their leases during the effective period.
Could I ask dovetail on that? Because, okay, let's say that I'm living in a complex and I'm in apartment D, but I'm going to move to apartment A now. So that 3% is not going to follow me over to apartment A, and then I'm going to have to pay this huge rent probably on my new apartment. Is that correct?
Correct.
Okay.
Based on my reading of the statute, that is correct. You're moving to a different unit, so it's a different contractual, it's a different contract. And
so it's for that individual in that apartment. Okay.
Correct.
Thank you.
But I want to clarify though, that if you rent apartment B and you rent it for whatever you rent it for, then the 3% then applies like thereafter.
Mhm.
It just doesn't, you can't be guaranteed that like moving from A to B, that, B's rent is only going to be like 3% higher than A. Like you would be renting B at whatever they're renting B for.
Right. Okay, thank you. I need to clarify that in our office.
There's an interesting question, and the FAQs that Jessica is referring to has been posted in the chat, and I'm sure somebody will probably throw it up again in the chat so that it's easy to find. There's an interesting question in the Q&A about when rent and fees are bundled into a balance, and a tenant wants to make sure that their payments are going toward their rent balance instead of their fees. Like how to handle that.
So Angie, that is a really good point. Where, I was mentioning, right, that folks have been evicted for fees, and that's because landlords will, misallocate that money. For example, let's say a tenant owes $50 for rent and $50 for fees, and they pay $50, right, in hopes that it's going towards rent, but the landlord puts it towards fees. They can still be evicted for failure to pay rent. And they were trying, to get caught up on rent, but instead the landlord chose to use that $50 for the fees versus the rent that was owed.
I think it also depends on how the landlord is filling out the complaints. Because if we come across a tenant who is summoned for a failure to pay rent case, if there were any additional fees that were listed on that complaint, of course, we would argue that those have to be taken off. Now, of course, that doesn't remove them from the actual ledger. So that could be, the landlord could file a separate action seeking like contractual damages or something like that, a civil case. But for the purposes of an eviction hearing, we would always argue against that. Even in some landlords, they'll say, well, they disagree with us, but we say that the rent payment should be applied specifically to the rent. And that is what the court is concerned about. And I think that just goes into the importance of legal representation. We're able to identify those fees that shouldn't be included.
All right. Any last questions from members of the work group? I'm scrolling through the questions in the Q&A, and I think we've hit on a lot of these topics. As we start to wrap up, I want to thank Community Legal Services and CASA for talking to us about this issue. I think there are a lot of issues that were raised about the tenant perspective that hopefully gives the work group some fodder for the kinds of things that we want to dig into over the next year, the kinds of things that we may want our consultant to collect more data about, so that we can, really figure out what are the types of protections that can and should feed into a permanent policy. We will be back tomorrow evening for the last of these early fact-finding sessions. We will be back tomorrow with the Apartment and Office Buildings Association, or better known as AOBA, and several of their members to talk about this issue from the landlord perspective. You know, one of the difficult things that I think the work group will have to do is to really balance in their recommendations, you know, this issue of how we have good housing policy in the county that promotes housing stability, that prevents evictions, that promotes affordability, but then also, you know, how we make sure that landlords have the resources that they need to keep their buildings up. And so these sessions are, and as I said, fact-finding and an effort to sort of put a lot of issues on the table early. So that as we dig in, we can take these different perspectives into account. So hopefully folks are signed up for our session that's taking place tomorrow night. And then I said this at the beginning, if anyone missed it, the work group is going to officially begin its work soon. And as part of the work group's official work, we will be hosting some more sort of town hall type sessions that will give the members of the public a chance to weigh in again on these topics. But we wanted to do these sessions as a way of really giving the work group a chance to start to dig into the work. So with that, I think we are going to end for this evening. Please keep a lookout for our posting of the slides from this evening, as well as the video from this evening should continue to be available for anybody who wants to watch it again, or for others who may have missed it to tune in later to hear this dynamic conversation. So thank you to our panelists, and hopefully I'll see all of you tomorrow night.
Thank you, Angie. Thank you all.
Thank you.